Appellant is Samad. It's from High Court of Telangana. It's a follow-up case of Shabano case and Daniel Latifi cases on Muslim women right to maintenance under Section 125 crpc vis-a-vis the 1986 Act, Section 3 to 5 for Muslim women divorces. Background. Appeal overview. This appeal challenges the High Court of Telangana order that reduced interim maintenance from rupees 20,000 to 10,000 per month. The initial order was passed by a family court in favor of the respondent under Section 125 crpc. It is a matrimonial dispute with the appellant, the husband, and respondent wife married on 15/11/2012. The respondent left the matrimonial home on 9/4/2016 and filed a criminal complaint against the appellant, leading to divorce proceedings initiated by the appellant. Maintenance dispute. The respondent sought interim maintenance under Section 125(1) crpc, which the family court granted at 20,000 rupees per month. The appellant sought to quash this order in High Court based on 1986 Act for Muslim divorces, resulting in a modified maintenance amount from 20,000 to 10,000, but upholding the application of Section 125 crpc. Against this, the husband has gone to Supreme Court, challenging the application of Section 125 to Muslim divorce. Now, legal arguments. Appellant's contention. Jurisdiction. The appellant argues that Section 125 crpc does not apply due to the Muslim Women Protection of Rights and Divorce Act 1986, which provides specific remedies for divorced Muslim women. The second issue is special versus general law. Citing precedents, the appellant contends that 1986 Act, being a special law, overrides the general provisions of the Section 125 crpc. Now, case reference. The cases like Mrs. Jaining Manufacturing Company versus Life Insurance Corporation of India and Daniel Latifi versus Union of India are cited to support the supremacy of special laws over general laws. The court appointed amicus curiae Mr. Agarwal. Amicus curiae's views. Non-exclusive remedy. He argues that Section 125 crpc is still available to divorced Muslim women despite the 1986 Act. Next, rights under the Constitution. He emphasizes, the amicus curiae emphasizes that denying maintenance under Section 125 crpc would infringe upon the fundamental rights under Articles 14, 15 and 21 of the Constitution. The case law. It refers to Daniel Latifi and other conflicting High Court decisions to highlight the ongoing legal debate on continuing applicability of Section 125 despite the availability of 1986 Act for Muslim women divorce. Now, court considerations. Legal examination. Historical perspective. The court will consider the historical and legal context of maintenance provisions under both Sections 125 crpc and the 86 Act. Clarification needed is, the court aims to clarify the grey areas and conflicting interpretations between secular and personal law provisions regarding maintenance for divorced Muslim women. The legislature in 1986, through Section 488 of the Criminal Procedure Code 1898 and later Section 125 crpc 1973, aimed to provide an effective remedy via summary procedure for maintenance to a wife, including a divorced woman and others like father, mother and child, whether legitimate or illegitimate. Section 125 crpc 1973 outlines that a magistrate can order a person with sufficient means to pay monthly maintenance to his wife, including divorced wives, minor children, legitimate or illegitimate, adult children with physical or mental disabilities, married or unmarried, and major or minor, and elderly parents if they are unable to maintain themselves. The provision also includes interim maintenance during proceedings and mandates that maintenance orders are enforced from the date of application or order. Numerous court decisions have established that Section 125 is a social justice measure intended to protect weaker sections in society irrespective of the personal laws, in line with Articles 15 Clause 3 and 38 Clause E of the Indian Constitution. This preventive measure aims to avoid vagrancy and destitution among the women. The burden of proof lies on the wife to demonstrate her inability to maintain herself and the husband's sufficient means to pay maintenance. In Shabano case 1985, highlighted that Section 125 CRPC 1973 applies universally, including to Muslim women divorcees, and is not overridden by personal laws. The subsequent controversy and enactment of the Muslim Women Protection of Rights and Divorce Act 1986 Act clarified maintenance rights for divorced Muslim women, reinforcing that these rights are not confined by personal laws. The 1986 Act, specifically Section 3, mandates that a divorced Muslim woman is entitled to a reasonable and fair provision for maintenance within the iddat period from her former husband. This law was challenged but was upheld by the Supreme Court in Daniel Latifi 2001, which interpreted it in a manner that upheld the constitutional rights of divorced Muslim women to maintenance, ensuring they are not left destitute. Subsequent cases like Shabana Bano 2010 and Khatun Nisa 2014 reiterated that divorced Muslim women could seek maintenance under Section 125 CRPC 1973, regardless of the specific provisions of the 1986 Act, Section 3 to 5. The Family Courts Act 1984 has also been interpreted to allow family courts to exercise jurisdiction under Section 125 CRPC 1973 for the benefit of divorced Muslim women, as seen in Shamima Faruqi case of 2015. Overall, Section 125 CRPC 1973 serves as a secular provision ensuring maintenance for wives, children and parents, including divorced Muslim women, to prevent destitution and uphold their right to live with dignity under Article 21 of the Constitution of India. Now, Section 125 CRPC about maintainability. A petition under Section 125 of the Criminal Procedure Code is maintainable before the family court as long as the petitioner does not remarry under Muslim women. The maintenance awarded under this section is not limited to the iddat period, a period of waiting prescribed under Islamic law following divorce or husband's death. Interpretation inconsistency. The principles applied in interpreting Section 7 of the Family Courts Act 1985 align with those in case of Khatun Nisa, affirming the applicability of Section 125 CRPC. Section 3 of 1986 Act versus Section 125 CRPC. Section 3 of the Muslim Women Protection of Rights and Divorce Act 1986 addresses a divorced Muslim woman's rights and entitlements from her former husband, not limited to maintenance. Under Section 125 CRPC, a woman must prove she is unable to maintain herself, applicable even during marriage, not contingent upon divorce. Next, time frame for proceedings. Proceedings under Section 3 Clause 2 of the 1986 Act should be decided within 1 month, unlike the Section 125 CRPC, which has no specified time frame but requires interim maintenance determination within 60 days. Non-compliance under 1986 Act can lead to imprisonment until payment is made or up to 1 year. Under 125 CRPC, non-compliance may result in 1 month imprisonment or until payment is made. High Court views post Daniel Latifi. What are different High Courts? Different High Court decisions on whether a divorced Muslim woman can seek maintenance under Section 125 CRPC came out with divergent views. Some judgments limit remedies to Section 3 of the 86 Act, while others allow recourse to Section 125 CRPC. Now, harmonious interpretation of this. Courts have found no express extinguishment of rights under Section 125 CRPC by the 86 Act. Both provisions address different aspects. They survive in different jurisdictions. Section 125 requires proof of inability to maintain oneself, while Section 3 of the 86 Act does not depend on such proof. Stare decisis and non-obstante clauses. Constitution benches have clarified that non-obstante clauses in Section 3 and 4 of the 1986 Act do not override rights under other legislative enactments. The High Court of Telangana upheld the applicability of Section 125 CRPC, affirming its decision by modifying the family court orders. Section 127 3 Clause B CRPC and maintenance. The divorced woman receiving full entitlements under Section 3 of the 86 Act without objection may still invoke Section 125 CRPC, subject to statutory protections against double payment. The right to maintenance under Section 125 CRPC persists unless adequately provided for under personal law or customer law and paid in due course. Daniel Latifi case and legislative intent. The Parliament intended for divorced Muslim women to receive sufficient means of livelihood post-divorce, not limited to the requirements of the iddat period. Maintenance under Section 3 of the 1986 Act covers the lifetime of a divorced woman unless she remarries. Application of Section 125 CRPC. A divorced Muslim woman can independently seek maintenance under Section 125 CRPC if she meets the statutory requirements ensuring no undue benefit is derived post-divorce. Section 127(3)(b) CRPC Acts cancellation of maintenance orders. If a divorced Muslim woman first seeks maintenance under Section 125 CRPC and then later under Section 3 of the 86 Act, the husband can request cancellation of the CRPC order once he fulfills his obligations under the 86 Act. The husband must show he has met his obligations and that the wife can maintain herself. Husband's obligations and wife's rights. Now, if the husband has fulfilled his obligation under the 86 Act or customary law and the wife then seeks maintenance under Section 125 CRPC, she can still pursue this route if she proves her inability to maintain herself. The husband must demonstrate that he has fulfilled his initial obligations and that the wife can maintain herself. If he fails to do so, the CRPC order stands, but he may seek other legal remedies. Reasonable substitute and double benefit. Maintenance orders under Section 125 CRPC can be reduced if the husband has already provided a reasonable substitute as per personal or customary law to avoid double benefits. In this case, 20,000 reduced to 10,000 by Telangana High Court. Coexistence of rights. The rights under Section 125 CRPC and Section 3 of the 1986 Act exist independently in their respective domains, allowing a harmonious interpretation. Despite the 1986 Act, a divorced Muslim woman retains the right to seek maintenance under Section 125 CRPC. Incorrect High Court decisions. Any High Court decision contrary to these observations are incorrect and bad in law and not valid. Affirmation of the Telangana High Court order. Telangana High Court order dated 13 December 2023 is affirmed and the appeal is dismissed. The above summary outlines the balance and interplay between a divorced Muslim woman's rights to maintenance under secular and personal law, emphasizing the conditions under which a husband can seek cancellation or modification of maintenance orders and the coexistence of both legal provisions. This is given by the Christian Supreme Court judge.